As Nigeria faces technological advancements, socio-political changes and increased demands for transparency and justice, it has become apparent that many of the laws drafted decades ago fail to keep pace with evolving times. Experts and legal scholars have long advocated reforms that reflect contemporary issues. It is for this reason that the Nigerian government in October this year inaugurated a committee of law experts from various fields to review, update and consolidate archaic Nigerian laws. The committee, chaired by Olawale Faponda, SAN, and co-chaired by Professor Jumai Alde, chairman of the Nigerian Law Reform Commission, is tasked with coordinating the collection and compilation of the laws of the Federation up to October 2024. The committee will identify omitted legislation from the 2004 edition, update and pinpoint outdated or redundant laws requiring repeal. They are also responsible for merging related laws to eliminate redundancy and will compile a comprehensive report of their findings for the Attorney General of the Federation and Minister of Justice. The review would also extend to some fines contained in the laws, which are now too small in the current inflationary situation of the country. This national assignment is expected to be completed within 6 months from the inauguration date. And as the committee embarks on this challenging task, legal experts are hoping for a legal system that truly serves the people and supports the country's aspirations in the 21st century. On Good Morning Nigeria today, guests will speak on the review of Nigerian laws and what it means for Nigeria.
Thank you, Ekene, for the background report there. And joining us here to discuss the proposed review of Nigerian laws, let me introduce Dr. Samuel Oni. Is the Associate Professor and Head of the Department Public Policy and Administration, Miva Open University. It's a pleasure to have you join us.
Thank you so very
for today's conversation.
It's my pleasure to be here.
Thank you so much for coming. Also here is Aliu Lemos, SAN, is a legal practitioner. You are welcome, sir.
Thank you very much for having me this morning.
Okay.
And we also have joining us via Zoom all the way from Addis Ababa, Ethiopia, Professor Joy Ngozi Ezilo. And she's a senior advocate of Nigeria, SAN, and officer of the Order of the Niger. That's, of course, OON. She's a distinguished law professor, emeritus dean of law at the University of Nigeria in Nsukka, and former United Nations rapporteur on trafficking in persons, especially with bias for women and children. That's between 2008 and 2024. Professor Joy, 2014, I mean, I beg your pardon. Professor Joy Ezilo, your resume is such that I found it difficult to abridge, but always a pleasure to have you on Good Morning Nigeria.
Thank you so much, Madam Claire.
Okay, let's start with you, Professor Ezilo, and let's just ask why is it necessary to review the Nigerian laws at this time, and how will it impact the country's development?
Yeah, thank you so much. I think, law is constantly evolving and very dynamic, and law reforms should bring laws to speed with modern socio-economic changes, including technological advancement. It ought to be, continuous, a constant phenomenon, and quite progressive in terms of, in fact, there is a slight technical distinction between law review and law revision. Maybe we talk about it, but let me just quickly talk about that. Law reform is supposed to be, progressively reviewing law, and it can be, painstaking, but it has to be ongoing. And then law revision talks about revision to update maybe a set of statutes that is obsolete. And then, but usually there is actually a term of years that every law ought to be reauthorized, if I'm to use some terms that is used in certain jurisdictions, like in the US. So the law is supposed to be constantly, reauthorized. And our laws are obsolete, so outdated that it's not even talking about 2 decades, but some have never been revised since they were handed down by the colonialists. So some legacy of colonialism, they are still there in our laws. There are ones that are so outdated, and we've been just cherry picking in terms of revision. But like I said, revision is different, and also we need both law review and law revision. So it is imperative that we review our law to harmonize it with modern development, conflicting areas, consolidate it, even codify some that are still part of probably customary laws that people are not aware, but yet governs a number of people, because that law regulates affairs of people and supposed to protect public interest, and then of course regulate corporation. Not that we don't make laws. The Constitution is very clear. National Assembly is empowered with lawmaking power in Section 4 of the Constitution 1999 as amended. But that's also different. And of course, several laws have been made since the onset of our nascent democracy in 1999. But you find that there are ones that are in the law. I can think of so many. Labor laws, Matrimonial Causes Act. There is a lot of conflicting laws. Uniformity is important, and it's important to have consistency and most importantly, constitutionality, because some are a bit conflicting now with the Constitution. And there are ones that are so obsolete that even in the light of ratified international laws, they are supposed to have been brought up to date, to be in uniform or harmonized to the obligation of Nigeria, whether regionally within the African Union or internationally as a member of United Nations. So that consistency is important. We have done...
Yeah. Prof, thank you. Yes. Prof, thank you. I see you. You are still talking, Prof. Thank you. You've raised 2 very fundamental issues. We all know that the world we live is ever evolving, and of course there is need for the way we do things to also evolve. To conform with the needs of the time. So our laws must be constantly, or should be constantly reviewed, and it must be consistent. That's the 2 things I'm taking away from the opening contribution. So let's also come back to the studio. Dr. Oni, who is head of department, of course, public policy and administration. I just would like to know what are the challenges that outdated laws are causing us, and what are some of those critical laws that are outdated?
Thank you so very much. We're talking about those things that the outdated laws are causing Nigeria. Quite enormous. If you're going to be looking at them, we're looking at the aspect of individual citizens. We're looking at the effect on governance and administration. We're looking at the effects on businesses. Okay, so the effects are quite enormous. Outdated law, you see, don't conform with realities. Okay, so that tends to make things very difficult. Okay, we talked about the digital age now, and as Prof said, some of our laws are colonial relics. Okay, and so you begin to find difficulties in trying to, this law, operating in this digital age with a legal framework that had been dated even before the digital age. Okay, ease of doing business, for instance. Okay, so the fact that we have laws that are outdated, laws that are conflicting, so makes business operations very difficult. You see, the way business operates now is different from previously. So we need a law that that sees, or that understand the peculiarity, the reality of the situation. So you can see that from the economic perspective, it's really causing a lot. Then again, individual citizens, for instance, we have some laws, as Prof said, our society is a kind of, it's evolutionary. Society is evolutionary, okay? And human interactions, changes. As it changes, there needs to be law that, reflect the changing nature. Okay, we talked about law, for instance, marriage law, basically customary laws. Okay, these laws probably worked in the past because of that social reality at that time. Now things have moved. So it becomes now difficult if those laws in the past will not be the guiding framework for this present day marriage issues. For instance, Child Right Act, for instance. Okay, so social involvement. Okay, I understand the fact that Nigeria is seriously involved, is a religious state, for instance, customs and traditions. But those things, for instance, which were not revealed then, now being revealed. Okay, I talked about, for instance, child marriage. Okay, so I talked about child marriage. Okay, those issues could be something that could work or could fit in the past.
At the time.
At the time.
But what now, about, let me even come to your area of discipline, which is policy formulation and administration. How do these outdated laws impact on policy formulation?
Okay, you see, the thing is this: policy should be at the interest of the public, and interest of the public changes. Okay, so changes with values, changes with realities of time. So that is it. If we still have outdated legal framework that informed policies, then policies itself becomes outdated by reasons of the legal framework that brings it on board. So seriously, on policies and administration, obsolete laws seriously, negatively affect policy formulation, policy implementation. Okay, you now have an individual, for instance, who, in this digital age, where informations and all of that can be collected through technology and all of that. But you now have a legal system which does not recognize this and recognize this. For instance, we talked about the issue of the Electoral Act. Okay, the Electoral Act, which is the legal framework for the implementation of elections in Nigeria. Okay, so if the Electoral Act is not up to date, I know it was reviewed in 2022, okay, giving way for electronically transmission of results, okay. However, even from then, there have been changes, or there are still some other areas that will need, update, okay, which would also impact administration of election in Nigeria.
Okay. Thank you very much, Dr. Samuel Oni, for your perspective there. Let's bring our conversation down to Mr. Liu Lemu, SAN. And you've listened to the two other guests, and they've given their own perspective about the need for the review of the law. From your own perspective as a practitioner, what are the key areas of Nigerian laws that you think they need urgent reviews, and why?
Okay. Thank you very much. See, being a practicing lawyer, day in, day out, we go to court and we see how the interpretation of this law affects the rights and liberties of individuals, how it affects businesses and foreign investors coming into Nigeria. Our laws at this moment are simply not living up to the realities of the world we find ourselves in today. Most of our laws are still colonial relics. And even the laws that were passed after colonization are still not adequate to meet up with the age we live in today. Since the turn of millennium, advancement in human society, if it used to be in months and years, it's now in decades. You see the advancement of the advancement of digital technology, the internet, has turned the whole world into a global village.
Yeah.
So our laws should not be only cater to the needs of Nigerians, but to cater to the needs of an evolving and a fast-moving global community. As I speak to Nigeria, it's very, very, very far left behind. In fact, it is only until the recent few years that the government is actually making serious efforts to make our laws meet up with the global standard, as there's an urgent quest to have foreign direct investment come into Nigeria, because the Nigerian economy cannot develop alone in isolation. Mm-hmm. We need foreign direct investments in Nigeria to help stimulate our economy. So foreign direct investment cannot come into Nigeria when your laws are obsolete. Our court system does not even encourage foreign investors to come into Nigeria. When you have your dispute before the court, they take years. They are for example, I think a few months ago we were at the Supreme Court during the validity session of one of the justices of the Supreme Court. There was a case that lingered in Nigeria for over 40 years. Wow. The case was started by a lawyer whose son took over. The case started before the son was born. The son was born, went to school, university, law school, was called to bar, and then continued that case. So imagine a foreigner who wants to come and invest in Nigeria, and then a dispute arises in the course of business, and then this business has to take up to 40 years. How does that encourage foreigners to bring direct investment into Nigeria? So every day, apart from foreigners, you see, every day in Nigeria, you see the common man, justice is being delayed. And in most cases, justice delayed is justice denied. Cases linger in court for lengthy and donkey years. That does not inspire confidence in the system of administration of justice. So more needs to be done. You see, the only thing we prioritize in Nigeria, unfortunately, are elections. After every 4 years, electoral law is being reviewed. The same should apply to other areas of human endeavor. At the very least, we say 5 years. This law should be revealed in 5 years. The ACJA, Administration of Criminal Justice Act, which was passed by the National Assembly in 2015, it took over 20 years to pass that law, because the previous one we had was in the 70s. From 1970s to 2015, about 40 years before the criminal law was amended. Now, even the ACJA is almost semi-obsolete. ACJA was passed in 2015. That's the most recent Administration of Criminal Justice law we have in Nigeria that applies federally. It's like by next year to be 10 years old. And even that is not able to keep up with the fast development we're experiencing in our society today. So on a daily basis, we see it, how it plays out. And judges will tell you their duty is only to interpret the laws. Mm-hmm. They don't make the laws. It is these laws that have been passed by the National Assembly, however long they have been passed. That is the laws that the judges can only interpret, and that is the law that applies to human behavior. And so far, it has been inadequate to cater for the fast-evolving human society we live in Nigeria today.
You know, you have touched on a very important aspect, referencing the lawmakers.
Yes.
Of course, it is the responsibility of the lawmakers to make laws. And that's why, Professor Ezilo, before we even move further, let's look at the source, where this review is coming from. We're talking about team of legal professionals who have been put together to review an existing law. Ordinarily, it is the responsibility, it is within the purview of the national and state assemblies, to make these laws, except, of course, if there is an executive, bill coming in. So, I'm just, is this the right move? Will the National Assembly and all the lawmakers not feel, I mean, this is a usurpation of their responsibilities?
You're left out.
Still back a lot of distinctions. The constitutional powers given to the National Assembly to make laws or State Assembly to make is there. And you can see that they are making laws, but laws that are just dealing with the immediate needs as they see it, with executive bills or their own private bills. You will see that since onset of our democracy, one of the first set of laws, ICPC Law 2000, then you have the EFCC Act, then you have cybercrime, some other laws, several of them, Terrorism Act, Anti-Trafficking Act, that's the NAPTIP, the one that established NAPTIP, and so many others. But look at them, they are just dealing with issues so they are forward-looking, kind of, not just saying maybe I'll use this in a limited sense, because some of the laws, if I critique it, are not that forward-looking. But some are forward-looking, but they are making laws for the immediate. They are not going back. It is not their tax to review law, but they can also, by making new laws, repeal the one that existed. But the problem, of course, we run a pluralistic society, and sources of our laws are quite many. And then we are a federation. The federal and the state also have competencies to make laws. And we have national, law reform commission. Let's not forget it. This is an important institutional mechanism for continuous review of laws and revision of laws within the contemplated period of time, like 10 years, 15. In some climes, 5 years, they will review laws, they will reauthorize. But in Nigeria, we have not been living up to that expectation. It requires expertise, but everything is reduced to political appointment. People that are not people who are supposed to occupy certain positions are put in there, and the result is that we spend money, we maintain institutions, and then we do the same thing over and over without a substantial result. I want to say, I hope with this, because the Attorney General have given his commitment and is determined, I can see from all his personality, to see that these laws are revised, and they have put in place a highly competent individual. But I want to tell you, 6 months is not it for law reform. It requires a lot of thoroughness. I don't know what exactly is their mandate, because I hear review, and like I said, review is different from revision. But what I expect them to do is both codification, both the harmonization, both review, both revision, so that they will bring our laws to speed with contemporary needs, and they will remove obsolete laws. Unnecessary laws will be deleted, so to speak, from our status book, and then ICT technology will take place. I cite example, for example, there are ones that nobody is even observing. That's nobody even know that there is a law. For example, people working a night shift like nurses. The law prohibits night work for women, for example. And then you see that there are. So can you imagine our hospitals without those nurses? And nobody obeys this law. The laws also prohibit underground work for even female, including female engineers. And I'm sure in some places and oil companies, people are even going about their duty. I recall one time I took a case of a mining engineer who was refused employment then in the Ministry of Mine, and I wrote to the then Attorney General, late Bola Ige. And I recall, I still have his response. I'm out of the country, I will have been. He said, Joy, my learned friend, go and be pushing, let's push for reform and the review and revision of the labor law. Because if that is done, it will bring it up to speed and deal with the issue. That the issue that is being, that she's fighting against is prohibited by law. But it's just because it's a single case of a woman. I think she was, I was fighting for her case there. But these are things that are in our laws, and there are so many in the criminal law, not to talk of the fines and punishment. Some are laughable. If you look at, you're talking about 15, some are laughable because they are not even in line with even the economic, values and, and then our even entire socioeconomic development. So let us not forget we have National Nigerian Law Reform Commission. Are they doing their work? I may not be able to answer that. But these things are institutional mechanisms that's supposed to be activated. It's not just a duty of National Assembly, or they will be making laws as empowered. They can also repeal laws. But then the old laws and revision, they have to do it and bring it to their attention for necessary action.
Thank you very much, Professor Ezealo, for your view there. Now, we all want to also join our guest in Jos studio, that is in Plateau State. Dr. Shijuade Kayode is a legal practitioner. Dr. Shijuade, you're welcome to Good Morning Nigeria.
Thank you very much and good morning.
Let's hear your own perspective concerning the proposed review of the Nigerian laws. I mean, I'm sure you must have listened to our guest, their perspective, and also the constituted committee that have been set up by the president to review the law. And besides your perspective, what do you think? How do you think the general public also can be involved in the review process? To make it more transparent and also inclusivity in this process.
Thank you very much. I think the review of our laws cannot come at a better time than now. Law is constantly changing because of the realities of our time. And I think the panel that has been set up is a good thing. They will be working with the National Assembly, the Institute of Advanced Legal Studies, and other stakeholders in the review. Now, to carry the public along in this review, we have been advocating for a helix model in what government do. For example, in this review, not just governments, the public, the private sector, the academia, the youth, faith-based organizations, cultural organizations, and civil societies must also partake in the review to bring to bear, their concerns and their contribution. So to do this, we expected that the committee should be able to receive memorandums from the public and even write to certain agencies or certain bodies to contribute to the review of these laws. In this way, we have a helix model embedded in the process so that at the end of the day, we have a law that speaks to the concerns and the needs of the larger society. Thank you very much.
All right, thank you, Leonard Sig there. Let's come back now to the studio, Dr. Oni. I asked Professor Ezilo, if the National Assembly will not, feel, reneged, so to speak. Again, we've had quite a number of previous reviews, even constitutional, reviews of our laws. We've had quite a number of, suggestions and recommendations that have been made that have not, been enforced or implemented. Assuming that in the course of this review, this latest review, the team comes up with a review that, okay, since, both the House of Reps and the Senate, speak on, almost similar, issues. And then when there's need for a wider room, both come together and deliberate. Why don't we have the bicameral legislation as has been, advocated? What if the review, this review comes up with that decision? Will it be binding on the National Assembly? What do you think the National Assembly will do?
Thank you so very much for that very germane and critical question. The fact that the review will come back to the National Assembly for deliberations, for further deliberations, and to pass to law is an issue. Going by the fact that the National Assembly itself is a political institution, okay, and made up of individuals from different constituencies representing different views and all of that. It's going to be a very challenging issue. It's going to be a very challenging issue, going by the fact that previous reforms like that often die in the National Assembly. It's either it's been tinkered with, reviewed, reformed, and watered down, or all of that. What you see, the country is becoming more civilized, and you see, these individuals are also coming from different strata of the nation, and it's the responsibility of Nigerian citizens to begin to hold their representative, yes, accountable, so that we are saying you are representing us, and this is what we want. This is what we are saying you should go and do. So if that happens, I think it's the review and the reform should be able to sail through, knowing fully that the review, as you have said, may also affect the National Assembly itself.
Okay.
Professor Izilo has time to. Yeah, so we need to speak with her.
Okay. Let's have the prof, because what Dr. Samuel Oni said is that the review is likely to face some challenges. What are the likely challenges that this review is likely to face, and how do you think they can be addressed?
I hope I got your question. Can you repeat the question? There was a glitch.
Yes, I mean, from what Dr. Oni said, the review is likely to face some challenges. And I'm asking you that what are the likely challenges that the review is likely to face, and how can they be addressed?
I think once they have the resources, the capacity, and then also you have to think of the financial, and I'm sure since it's the federal government from the presidency that they have what they need. But usually, like I said, law reform in general, because law reform will embrace law review and law revision. It's a painstaking job. It requires that kind of thoroughness. It's not something they can even achieve in 6 months, let me be honest, unless 6 months they want to identify all the laws that needed to be reformed by way of either review or revision. But then the challenges have always been there. Challenges of, because of the nature of our system and the sources of law. It's hush-push of laws, and then we have also other cultural values. The constraints must be tackled for them to be move ahead. But I believe with the presidential fiat they have already to inaugurate that committee, that they have all the political and economic leadership will from the part of government to pursue that. But I just want to give a final, my final statement, because I'm on a mission, as you are aware. I'm one of the 3 UN expert commissioners on Sudan conflict, and I'm in Addis Ababa. We're making a lot of consultation, and I have meeting in the next few minutes. So I think the business of revision and review exercise, it must focus on eliminating all repealed laws. You will see some laws repealed. People are not even aware. Law must be clear, must be certain, must be concise, must be predictable. So they must focus on eliminating all of that, remove it from our status book. All the confusing laws that people don't even know have been obsolete law must be deleted. Those unnecessary that have been overtaken by modern socioeconomic changes must be removed. They are no longer, they have outlived their usefulness. And we must come back to institutional mechanism and reforming institutional mechanism for law reform and continuous law review and revision, including the work of legislators. I want to see at the end some of the things that are in conflict, conflicting laws also dealt with and handled. For example, you'll be surprised that under our law, a woman can still be chastised by the husband. You'll be surprised that under our law, Matrimonial Causes Act is at variance with the practice. If he says that a woman's matrimonial home is that of her husband, and then you have the policies of state of origin saying the other way. You also look at the issue of age of marriage we don't have. You look at the labor laws I've mentioned, the ICT laws, corporal punishment still allowed under the law. This is even unconstitutional. Degrading treatment, even corporal punishment, both at school and as a way of punishment by the court. There are a lot of, I don't want to go into practice direction and guidelines and the rules of high court because those ones can be amended by the institutions. I want to also say that Nigerian Bar Association is focused on this law review and bringing our laws to date. The president, Mazi Afamosigwe, senior advocate of Nigeria Life Venture, has inaugurated justice reform sector, and I am the chairperson of that justice reform sector. And we hope we're also looking, and the committee members, so it's one area that, of course, the MBA will cooperate fully with the federal government. We'll be making submissions to those who are working under the committee that has been set up by the Attorney General of the Federation and the presidency. And we hope that together, because it requires a lot of coming together and then avoiding all of the usual pitfalls that divide us, that also constrain law reform in Nigeria. That's why we still end up with colonial laws that have long been even deleted from the status book of those colonial masters. So time is now, and we must seize this opportunity. Thank you once more for this opportunity. Thank you. I'm sorry I have to leave.
Thank you very much, Professor. Time is now, and we must seize this opportunity. We have to let you go now. Thank you so much for your contribution, Professor Joy Ngozi Ezelo, Senior Advocate of Nigeria and Officer of the Order of the Niger, OON. Thank you so much for your contribution, and we wish you success in your assignment. Thank you.
Thank you.
Claire.
All right, yes, let's bring in Leonard Sink Lemu into our conversation. And I was just going through the terms of reference for the tax team. And I just discovered that basically they are to look at, sorry, I just want to bring it out now so that I don't misquote. Yes, I don't misquote. Yes, okay, find that to identify all legislations that are not included in the 2004 edition of the LFN. That's the legal framework. Yes. And then identify outdated, I think this is probably the most important aspect. Yes. Identify outdated and redundant laws in the current LFN that need repeal. And then the other one is merge laws addressing related matters to eliminate, redundancy. So, and it would appear that the task or the assignment of the team is not as enormous and rigorous as we thought. Yes. It does not imply that this team will go into the spirit of the laws, but rather just superficial. Yes. So does it still address the issues that we are
not really superficial. I think this is a first step to many other subsequent steps that will follow. Please permit me to contribute to the previous question as to whether there will be challenges before the National Assembly. Okay. Even though the National Assembly has the constitutional role to pass law, but initiating legislative action is not the sole responsibility of the National Assembly. Even the executive have a role to play in initiating bills before the National Assembly. So I don't see any conflict arising from the executive initiating this law review process. Okay. It is an action plan that will be presented before the National Assembly. So all of the repeals that are to be made, all of the amendments that are to be made, all of those are going to be made by the National Assembly. So it will be the work of the committee is to provide an action plan to the executive, which the executive will now present to the legislature for legislative action. So that covers that question. There might be challenges that will arise, perhaps in respect to the laws that personally affect the interests of the members of the National Assembly. But that's a different thing altogether entirely. But now let me come back to the question you just asked me. There are two aspects of this assignments that I think are being misconceived. You see, this exercise does not affect the provisions of the Constitution.
Yes.
The constitutional amendment is another task entirely, because the Constitution affects all arms of government, all citizens of Nigeria. That task is a task that can be best initiated by the National Assembly. They have initiated several times, but they have not followed it up to a logical conclusion. Now, coming to the present action, the mandate of the committee, as given to it by the Attorney General of the Federation, is to review obsolete laws, take a journey into all of the laws we have in Nigeria and identify for us the ones that are obsolete so that we repeal them. If they need to be reenacted, we repeal and reenact. But if it's just simply to repeal them, we don't need them in our body of laws anymore, we repeal them. That is one. Two, identify redundant and conflicting laws. There's a law called Koboko law. There's a law called promise and fail law. You promise somebody you want to marry them and you fail. There's a law called promise. I wonder in this age and time.
In our laws?
In our laws. They exist in our laws. We have baby
promise and fail.
Yes. We have baby formula law that you must have certain inscriptions on a baby formula before they are
baby formula.
So this promise and fail law, just give us a little insight without even
and also the Koboko law.
Yes, okay. If a man promises a woman that he's going to marry her and he fails to marry her, under that law there's a penalty for him refusing to marry her.
And it has not. I don't think the awareness for this law.
No, so that's why our body of laws are many. So it's not all of them that
it has not been repealed.
It has not been repealed. Still part of our body of laws.
What about the Koboko law?
The Koboko law is the law that permits corporal punishment in our school and in lieu of imprisonment.
Okay.
That law is inconsistent with the provision of the 1999 Constitution, which protects human dignity. You cannot see because somebody committed a crime or somebody breaks some rules, he should be flogged publicly. That is degrading to human dignity. It is inconsistent with the provision of our Constitution. So you cannot have those kind of... But as I speak to you, that law which is inconsistent with the Constitution is still much a part of our laws. So these are part of the obsolete and redundant laws that this exercise is supposed to identify and bring before the National Assembly for them to repeal some of these laws. The ones that have to be enacted will be enacted. There are calls to merge ICPC and EFCC because they perform almost similar roles. Yeah. Maybe perhaps this exercise will identify an issue like that. Okay, ICPC and EFCC, because they perform similar roles, why don't we have a uniform law that will harmonize these two laws into one and merge these two institutions into one, because they perform similar tasks. Okay. So those are the primary functions this committee was inaugurated to perform. The task of law review, as Professor Ezola has said, is quite enormous, and it's not something that can be completed in 6 months, and certainly not by 46 people. Now
if we're looking at the effectiveness of the outcome of this review,
yes, ma'am.
Because you mentioned something about the merging of
similar,
which is again one of the attempts of reference. The Assembly has come up with this time and time again, and we are still talking about the same law. So the effectiveness of this, because Nigerians will be wondering, what will be the effectiveness of this review if we are having to repeat the same thing that other constitutions, and panels have, You
see, because I want to say perhaps, because of the democratic system of government we practice, which guarantees election after every 4 years, and then at certain times we have different political parties with different political ideologies occupying the seats of power. But it shouldn't be like that. There has to be continuity in government. We are all unanimous that the Orosai report is a good thing for Nigeria. We have too many parastatals, we have too many MDAs. We need to reduce their numbers for efficiency. A lot of them, like sometime last year, I think there was a news that one polytechnic that has just 146 pupils spent over 400 billion, something like that. That is not practical. Resources are scarce. And then you have institutions, duplicated institutions that waste government resources. Those are not effective. But I say, that's not the task of this committee. This task of this committee primarily identify obsolete laws, identify redundant laws, identify conflicting laws, and then identify laws that were not included in the 2004 laws of the Federation. Now, let me give you a little background explanation to that. Every year, since the coming of democracy, the National Assembly passes laws 3, 4, 10, 20 every year. So it is customary that after a certain period of time, the laws that were passed in 2016, 17, 18, 19 are all harmonized into one body of laws known as the Laws of the Federation of Nigeria. The last one we had was in 2004. Prior to that was in 1990. When they were compiling the 2004 laws, they omitted some of the laws that were not used. They are still very much a part of our laws, but when they came to compile the 2004 laws, due to human inadvertence, they omitted those bodies of those laws that were passed in the 2004 Act. Now, those have been identified, but because since 2004, those laws have not been amended, the Federation has also given them a further task that, okay, identify those laws from 1990 and previous years that were omitted in the 2004 Act. So that by the time we are reviewing a new law, if it is in 2025, we will not make the mistake of omitting part of our laws that were passed by the National Assembly or are part of our existing laws that were not incorporated in this 2005 exercise. That's the additional mandate of that committee, so that it makes it easy for anybody who is looking for any law in respect of a subject matter in Nigeria. All you need to go and do is to pick up the laws of the Federation of Nigeria in 2025 or 2026, where you find all of the body of laws in Nigeria in that particular singular statute.
Okay, so let me quickly introduce our guest who has joined us from Lagos, Sam Elanya. Sam Elanya is founder, editor, lawnigeria.com. Mr. Elanya, thank you very much for joining us. I'm sure you must be listening into our conversation, and we've gotten to the point where we're looking at the effectiveness of the task of this team, and if it's just restricted within the terms of reference, how does it then address the issue of concerns for a lot of Nigerians? And for instance, if I may just take the citizenship rights, for instance, because Professor Joy Ilu mentioned it.
I didn't get the full question. There was a glitch over from the side. Can you please repeat it?
I'm just saying that we've gotten to the point in our conversation where we are looking at the effectiveness of the job assigned to the team, the review team. If it's just to identify and pass on to the executive, should we be rejoicing, and how might it address issues like citizenship rights, as mentioned by Professor Joy Ilu before she left us?
Thanks for that question, and thank you for having me. It's important that always when we talk about law review, that Nigerians appreciate how we approach these things in Nigeria. In fact, in Nigeria, we have devised for ourselves two categories of law development that we embrace. We are the ones who fashioned that one. Is peculiar to us. So on one level, we have constitutional development, where we are all forever trying to become founding fathers. Everybody wants to make the constitution over and over again. Nobody says to us, there has to be an end to constitution making. The foundation is only laid once, and you build upon it, subsequently. And so because we don't do that, we don't understand how important what we are talking about now is, because this is the entire administrative complex of our country. Without it, our agencies cannot work well. Without it, all the things that go to satisfying or bringing about the Chapter 2 objectives of our Constitution will never come to pass. And so, why is this useful, or how can we look at it today? The first thing is to remember that their task is not to amend the Constitution, and their task is not to amend or to make new laws. I've heard quite a few of our panelists say some things I find disturbing. Elections have consequences, and there's a reason why we have National Assembly. And part of the reason is because of what we are hearing now. The idea that people can sit down in some hotel rooms or some halls or wherever, not elected, and sit down and review and remake the laws to bring about ideological conclusions that they would prefer. It's not what our laws envisages. And so when you look at what they are doing today, I already find difficulties, and I think perhaps I can start from there before I get back to what you asked me. The first thing is about the Law Reform Commission. I don't see how what is being done right now will pass muster legally, because I know some people are already preparing challenges to do it at the court level. Because under our laws, once the National Assembly prescribes a mode for doing a thing, if you follow any other mode of doing it, what you are doing is prima facie null and void. And at the moment, we just passed the law in 2022 for the National Law Reform Commission. Under that law, everything that has been given to this committee now has been fully and solely given to the National Law Reform Commission. You cannot take it away. Even that commission cannot by itself decide to delegate that function to any other body. The AG doesn't have the power to interfere with that. And so, except we remember that, first of all, we may just waste all these budgets, do all this work, and then somebody goes to court, it gets knocked out. Secondly, is to remember this: that law reform is not about trying to bring about an idea of society that we would prefer. The word there is reform, not deform or to invent new ideas. And in reformation, you have to go back to what happened in Europe. That's the reformation under Luther and Calvin and all of them. What were they doing? They were trying to restore, quote unquote, Christianity back to what it was under the Bible. So they screamed sola scriptura, which means you must show that everything you want us to have to live our lives by are in accordance with the scripture, identifiable in black and white. And that's what law reform really is about. And so we have at least like 3 platforms or vehicles for doing that. You have the executives, and their mode for doing that is Section 315, where they are allowed to look of the Constitution, where they are allowed to look at the provisions of the law, find out which laws predated the Constitution, make recommendations to the National Assembly, and get some of those laws, quote unquote, reformed. For instance, since last week we have been talking about what we call criminal defamation, which is embedded in a criminal code. That's the kind of provision that right now, because of the constitutional guarantee for expression or right of expression, we should have by now gotten that law out of our books. And that's the job of the president, the governors of every state, to say every Nigerian now has a constitutional right to expression. And so you cannot criminalize their speech in deference to the character or reputation of another Nigerian. What is the interest, public interest of the nation in that? We are not doing that. So that is the mode through which the executive can interfere with lawmaking. Now the judiciary also can look at laws already made, and when cases are brought before them, they can decide this law is null and void because they are inconsistent with the Constitution. And by so doing, they help to reform the law. Of course, the National Assembly, of course, by making laws, week in, week out, are doing the same thing. So what does the Law Review Committee now do? Their job is simply to bring all these things together. Bring them together. 1948, we did that. 58, we did that. 1990, we did that. 2001, it was begun and finished in 2004. And a law was made in 2007. In each of those, must have an enabling law pursuant to the committee, except to have a commission already mandated by law, in this case, our National Law Reform Commission, to do that. And so, what we are doing at the moment should have been get the gentlemen together, they come together, collect all these laws, consolidate what has not been consolidated as amendments, find what has been struck out through judicial pronouncements, and then renumber those laws, look at phraseology, and look at what, quote unquote, is difficult to understand, not interpreted. More importantly, and I will stop on this point, I hear a lot about redundant laws. There is no such thing as a redundant law. There's only a law amenable to Constitution or not amenable to Constitution. So you can't say a law is redundant because you in Lagos finds it so. How about the person in Zamfara State? You may be so sophisticated in Abuja or Lagos. The person in Nasarawa, Abuja, Zamfara, that same law you think is redundant can still be useful to them. And so that's why you have to go to the National Assembly. Go there and make your point. That is redundant, they will let you know. Thank you.
Thank you, and you've raised a lot of issues. We will come back because I would also like to know if the laws on citizenship and indigenship is either redundant or outdated or still relevant, you know, to the times in which we live. But let's veer off now. And I would like you to, if you're watching, I'd like you to, for a moment, imagine, you know, a new chapter of air travels. And for instance, just stepping off a long flight and, you know, you skip the lines at the immigration, you don't have to go through the queues, and that, you are onto a seamless high tech. Well, that's the reality we hear at the Nnamdi Azikiwe International Airport at the moment. Nigeria has joined the League of Nations, embracing electronic gates at the air borders. Victor Azu is already there, and let's see if he can take us inside this new chapter of travel convenience, and then we'll come back for the concluding part of our conversation. Victor, if you are there, please take it off.
9. These e-gates at the Nnamdi Azikiwe International Airport has been operational. Now it takes about 15 seconds to get people in here, and that tells of a very smooth entry into the country. Not only Nigerians, but foreigners who are coming in through this international wing of the airport.
This is very impressive, like in Nigeria, and I think it's a good step showing that we're moving forward as a country. Like, things are going to be way easier now. Like, when you're coming back, you don't have to join like long queues anymore.
We were here in October, and this is such an amazing system now to have in place. It's easier, it's less stressful.
So quick, so well efficient, and honestly, like, I thought I was back in UK, so it's actually quite good. It's actually quite good, yeah.
This is actually my first time flying into Abuja internationally.
Oh, okay.
So I'm pretty impressed with this. It was pretty quick as well.
Coming in is much faster, and it's the electronic process is working much better. So it's not like before we have to wait for the physical or the manual part. This is quite straightforward. And so those who can use it, we just use it and come in.
Having been to Abuja in the last 10-15 years, I'm really impressed with what I have seen here. And I do hope that the government can sustain exactly what's been done here, yeah, and the resources being put in place.
I'm arriving from Houston, Texas, transited in London Heathrow. Coming here, this is not only a welcoming surprise, but it's a very wonderful one. I commend the Nigerian Airport Authority. I commend the current administration for making this improvement. Though the network is a little bit slow, but it's a work in progress.
This flight just landed a few moments ago, and seeing the number of people already out here is testament to the smoothness of their entry using the e-gates. It's not what it used to be, and that talks about the experience that you get in developed countries of the world coming right here to Nigeria. From the Nnamdi Azikiwe International Airport, I am Victor Azu for NTA.
Thank you very much, Victor. What a good development there.
Wow.
I know that.
I think I think we should clap. Good. We should really clap for.
Really? Yes. Well, it's something that should be sustained.
You were wowed.
No, I was wowed, really. I was wowed, really. Most Nigerians were, really.
Okay.
Dr. Oni?
Yes. It's a good development. I mean, we keep...
Just one word for it.
I mean,
wow.
Very great.
Very good.
Very great. So we take a break. When we come back, the conversation continues. Stay with us.
When we think about the digital economy, you can see it as the marketplace for digital goods and services. And increasingly, it's becoming a force to reckon with and an incredible contributor to economic growth, because we've seen the growth in technology and digital platforms. Technology has it really permeated every aspect of life and business, the way we live, the way we work. And when we talk about the digital economy, we're really talking about leveraging technology and digital platforms in a powerful way to drive growth, to drive solutions to problems, to drive applications, and to provide services.
The digital economy is something that has the potential to help Nigeria leapfrog a lot of its development challenges, right? because think about what the mobile phone did for Nigeria years ago. That is the potential we have for digital, because it has a way of reducing the barriers to innovation. It has a way of being able to transform service delivery, whether it's government's delivery of services or whether it's services in the health system where people can use digital to actually be able to see their patients better. But it takes a lot to realize that potential of digital. The first thing is like every other thing, there's an infrastructure you have to build to be able to make sure that digital economy can thrive. Think of something like, capturing that happens in Nigeria, right? Where you capture, people's biometric when they go for a driver's license, when they go for passports, and each of those are separate things. Imagine a system where you're able to streamline that and actually have a platform that exchange biometric information that makes it easier for people to access passports, easier for people to register to vote. But today it's very tough, right? But those are basic infrastructure that needs to be invested in. A lot of it is through government and private sector collaborations to make it happen.
If we're looking to accelerate growth in the Nigerian space, we really need to look at enabling the digital economy. That includes providing digital infrastructure, connectivity, because that's the highway, like the highway that everything rides on. We need to think about digital capacity building in terms of the suppliers to the economy and also the consumers within the economy. So a robust digital literacy initiative. The good thing about technology is that, one, it helps you to transcend boundaries. Two, it creates a level playing field, really, because if you create a solution, a technology-based solution that is applicable in this environment, that same technology can be applicable, exported to other environments. And, technology platforms also help drive collaboration, right? When we're thinking about innovation, when we're thinking about business growth, collaboration is an important part of that. So when we think about the impacts with the rest of the world, we find that actually technology platforms are giving us an opportunity to engage more actively, to collaborate, to create partnerships, to even export our knowledge and services for people to engage with all the great things I'm talking about technology and digital platforms. They need access, internet access, broadband access. So we need to make sure that access is more available and affordable for the average user.
The most important thing is to think about where you want to go as a country and actually what type of policies are going to help get you there. There are examples of countries who've been able to transform using digital. For example, there are very clear things those countries did to be able to make it happen. So a lot of this, the pathway to be able to solve these problems are not mysterious, right? It takes courage of the policymakers to be able to understudy some of these things and bring in the policies that work to be able to help them.
You have to move from the point where you protect and defend your religion to a point where you also recognize the rights of the other person, of the other religion, and protect it. So if I am protecting my own territory and my own people and trying to emphasize their rights and protect their rights, I should also be thinking about how to protect the rights of the others.
Both Islam and Christianity recognize and defer to God, and both recognize the temporariness of the life of this world, and that ultimately we all go back to God for the day of reckoning, when everybody will render an account of his life on this temporary abode.
Thank you for staying with us. You're still on to Good Morning Nigeria on the network service of the NTA. We're still discussing the proposed review of the Nigerian laws. And let's go to our guest in Jos Studio, Dr. Sijuade Kayode. We've been talking about the review, but let's look at the mechanism for implementation and enforcement now. What mechanism do you think should be put in place to ensure that the reviewed laws are effective in achieving their intended purposes?
Okay, thank you so much for the question. I believe this ongoing reform is at the instance of the Attorney General of the Federation, and our enforcement laws and procedures are also part of the laws being reviewed. And if this is done, the Attorney General is to submit this by way of executive bills to the National Assembly for passage. And when they are passed, they will help in the enforcement and implementation of these laws. Because, as it were, Nigeria, we have very good laws, but the problem is in the enforcement and implementation of these laws. And if the implementation and the procedural laws are strengthened, this will allow the agencies responsible for enforcement and implementation to also carry out their work effectively and efficiently. So this work is a huge one. And of course, saying that the committee should finish this work within 6 months is just a template. The time limits can be extended for them to, consolidate or finish the job, as it were. But it's good that they have started. And this will grant, Nigerians the opportunity to also contribute to the lawmaking, the reform process, as it were. So the most important thing is that the enforcement procedures and the laws should also be part of these reforms, so that this will give the agencies responsible for enforcing the laws more power to become efficient and deliver on the goods. Thank you.
Thank you very much, Dr. Kayode. I know that when Elaya was speaking the other time, Elaya was speaking the other time, you were itching to respond to some of his comments. Would you? Okay, you have the time now.
Well, he made the allusion that it is taking away the functions of the Nigerian Law Reform Commission. Well, this is not the forum to argue, but I think I hold contrary views. Okay. The Nigerian Law Reform Commission is much a part of the assignment of this committee. Statutorily and constitutionally, the law gives them the mandate to perform this task over time, periodically, to advise both the Executive and the National Assembly on the aspects of our law that needs reform. But that is slow in coming. Now that the Executive has initiated this law reform function and have co-opted other members of the society jointly with the Nigerian Law Reform Commission, I don't think there's a breach of any law in that respect. If anything, it gives more political impetus to the performing of this task, and it will all relate to achieving the result that we all want from this exercise. Nigerian Reform, the committee is being chaired by the chairman of the Nigerian Law Reform Committee, Professor Jumai Audi, who is a very renowned professor and was my lecturer in the university. And then we have other senior members of the legal profession. I counted at least 6 senior advocates in that committee. We have retired justices, we have academics, we are members of the academia, and members of the legal profession in this committee. So I believe that we are all striving to achieve the same goal the Nigerian Law Reform Commission is striving to achieve, and I don't think there's any conflict. And all of this, they are to provide a template. Members of that committee cannot amend any law, with due respect. Members of the committee are not tasked with amending any law. Members of that committee are not tasked with deleting any obsolete law. They are supposed to provide an action plan, a report to the executive that appointed them. That, okay, this is what we have observed, that these laws are obsolete. They need to be either repealed or reenacted or amended. These laws are redundant to the extent that the provisions in respect of which they were made are no longer operative in Nigeria. And as such, they are redundant. And then we also have to distinguish the fact that Nigeria practices a federal system of governments. The only extent of the work of this committee is in relation to federal laws. And as such, the laws in Zamfara State or the laws in Plateau State or the laws in the Benue State are not affected by this exercise.
Can I just put you on hold?
Yes.
Let me take, I just hope that, I wish we could have the terms of reference, displayed. E and F under the terms of reference says, merge laws addressing related matters to eliminate redundancy.
Yes.
Thereafter, prepare a comprehensive report of findings to the Office of the Minister of Justice. Perform and undertake any lawful assignment incidental thereto. So it's not just identifying and say, okay, law A is outdated. We need to do this. Law A. They need to take that out.
No. What they can do is to make that proposal. What that term of reference is saying, they are supposed to submit a report that will be in the form of proposal. That this is what we have identified, and this is what we are advising. So this committee on its own cannot amend.
Okay.
The Attorney General himself, with all of the power he has as Attorney General, cannot amend or repeal any law.
Let me also put it to you before we go to Elanya.
Yes.
In the event that whatever they come up with, they submit to the executive.
Committee. It is going to be a report.
A report.
Yes.
The report is presented to it's presented to
the Attorney General of the Federation.
Who in turn will present
who will in turn decide whether he's going to accept the terms of the report or what they have proposed. He's not going to take everything they have brought hook, line, and sinker and say, okay, National Assembly, this is what we want.
No, but okay, the executive will have to accept that report.
Yes.
Once the executive accepts the report,
yes.
Of course, the National Assembly will have to.
No, they will not present all, some, or part of that report as an executive bill to the National Assembly.
That's what I'm saying. Just hold on. Yes. What I'm saying is that the National Assembly will still have to sit over whatever was.
The function of passing or amending law is exclusively the function of the National Assembly.
Good. Now, assuming in a situation where the broader or intention of what has been submitted conflicts, you understand, with the opinion of or legislative process and all that. As in the case of, because I know, I want to believe that would also come up. The issue of why don't we just have one legislature? Just either,
The function of those committees does not extend to that.
No, what I'm saying is that it's part of the law.
No, it doesn't. Sorry, Doctor.
Okay.
Before you
do something.
Okay.
You just made some certain points now.
Yes.
It is important for us to know that Nigeria is a federal state.
Yes.
Okay. And part of the review is to point out inconsistencies. Okay?
In the federal laws.
Yes, in the federal laws.
Yes.
Okay? If we're talking of inconsistencies, for instance,
yes.
We're talking about, for instance, let's look at this case, this forum shopping.
Yes.
Okay, an instance where, someone, we seek judgment from different courts. Okay, whether the state high courts, the federal high courts. You see, when we say federal, there are some certain laws that are both federal and, as the same, state, concurrent laws. So if you look at it holistically, it's not just about federal laws. It's about laws across the whole country. So it's not as that simple as that. And the fact that you talked about the National Assembly, that is it. That was out of my first comment. That you see, all of these issues comes back to the National Assembly.
Yes.
Prof talked about some certain customary laws that have been obsolete. The terms of reference is repeal. So what does it mean by repeal?
I want to believe the language is to propose the repeal. I want to believe because
it's not.
It's clear. It says repeal.
No, they
can repeal obsolete laws.
No, they can't. That's what I'm saying. That from a constitutional standpoint and from a legal point of view, no person or authority in Nigeria has the authority to amend, repeal, or expunge any law in Nigeria except the National Assembly.
Yes.
Can Sam Elanya weigh in on this? Sam, are you there?
Yes. I'm here. Can you hear me?
Yes, we can. Can you weigh in on this?
Yes. Okay, let me just respond to a few things he said. The first thing is that federal laws does not concern somebody in Zamfara State. If that were the case, why have a National Assembly? Many laws being made in Abuja, okay, apply across the 36 states. And sometimes they apply in some certain places more than the others. Sometimes they are more useful in a certain place more than the others. Laws that relate to timber and wood doesn't concern you in Abuja or in Lagos because maybe you've not seen a tree in a long while. But somebody somewhere in the bush, somewhere in Calabar, maybe Cross River State or Bayelsa, okay, it concerns him. It may look redundant to you, but it doesn't look to them. Laws regarding gender and marriages that perhaps for those of us who are sophisticated, who now want to go work, who wants to begin to do what we need all over the places, it might seem like that's the best thing for you, but for a conservative Nigerian somewhere up north, or perhaps somewhere in the eastern heartland, such laws become redundant, perhaps might be how they think they can best effectuate the harmony and stability of their families, which is why you must have first, second, third readings, go into committees, come out there, debate it openly. And so if you can do that, then the law can be changed for review. That was the first thing you indicated. So that wasn't the point that I went remiss to address. Second thing I said that perhaps you didn't get is that this function belongs to the Nigerian Law Reform Commission. I can read you the act. Recently passed, 2022. Everything in that so-called mandate of this committee is given to them. Every single one of them. Not just that. You said erroneously, I'm not sure you have researched that the current chairman of that committee is the chairman of the Law Reform Commission. It's not true. The current chairman of that committee is Wale Fakonhunda, SAN, former AG of Ekiti State. Is not the chairman or head of the Nigerian Law Reform Commission. So that is already there. Third thing you said that you might want to look at again is this. You indicated that after all this work, what will happen is that they will take it to the National Assembly with an executive bill. That's not how it happens. You can look at it. 48, 58, 1990, LFN, 2004. What happens is that you go through this work. When you are through, you go to the National Assembly. Just one law, an omnibus law is passed that simply says all the laws here are attached to this list as a schedule and hereby from today the laws of the Federation of Nigeria. There's no executive bill for each and every one of them. And that's why our laws over time have insisted that you do not allow this function to be led on a partisan or as an executive function. It has to, usually it is led by very senior judges who are put into a place in their life where partisan consideration and no longer what they think about. And that's why you have the Law Reform Commission. Because over there, people there looking at all of these laws, beyond just trying to effectuate the policy imperatives or preferences of the PDP or APC, you want to give effect to whatever are the policy pressures you want to deliver so that you can win the next election. That's not what this kind of function is about. That is why you have to go to the National Assembly. And so, I want to restate again that why this is such an important thing is that the last one that we did was done in faraway South Africa. Lexis, Nexis, South Africa, more or less, was a principal driver of the former one. That's why we missed out so much. Because they were in a hurry, take our law to a far off land. We don't even know what they have done with those.
Sorry, Sam. Yes, I'd just like to again amplify what Leonard Sik here said. The Professor Jume Audi is the co-chairman. Is the co-chairman of the review team,
as well as the chairman of the Nigerian
yes, and the chairman of the Nigerian Law Reform Commission.
I get that, man. I need to remember what I said before. Not even the chairman can, of himself or herself.
Anyway, okay, thank you so much. Thank you. Because of time, we don't have time. Let's go to Joyce to get his parting words. Dr. Shijuade Kayode, maybe you have one or two contributions to make to the conversation that is ongoing. Briefly.
Sir, I would like to say this. Section 5 and Section 7 of the Nigerian Law Reform Commission gives the Commission the power and the Attorney General also the power to set up this kind of committee to work with the Commission and other stakeholders for the amendments or reform of laws. So the committee is legal by virtue of those provisions. Now, for my final words, I will say laws are for protection of life and property, and for the general well-being of the society and progress of society. Now, in this law reform, I would like the committee to look at the areas of laws that are creating conflicts in the country, that are being disputed in the country. For example, economic laws, land use, terrorism, crime, cyber attacks, and the digital technology, the digital laws.
Thank you so much, Dr. Kayode, for that. We're sorry we cannot take much from that. We need to sign you off now. Dr. Kayode, Shijuade Kayode is a legal practitioner that joined us from our Jos studio. Thank you so much for your contribution this morning. Also, we want to thank Sam Elia, founder, editor, lawnigeria.com. Thank you also for your contribution to today's conversation. Also, we want to thank Dr. Samuel Oni, Associate Professor and Head of Department Public Policy and Administration, Miva Open University. Thank you so much.
Thank you.
And Aliyu Lemo, SAN, Legal Practitioner. Thank you so much for coming.
Thank you very much for having us this morning.
Thank you.
All right, and that's Good Morning Nigeria for this Thursday, and I think we really need to look at this issue again in depth now. There's so many laws, that do not align with, of course, modern reality. Anyway, I'm Claire Adelabu Abdul-Razak. Bye-bye.
And I'm Ademola Adeoye. Thanks for joining us. Have a wonderful day.